Hi, my name is Thabo and I've been thinking about drafting my first will. My family doesn't think I need one as I don't have kids, but I'd like to have things in order in case something happens to me. Could you explain the basics of what needs to be included in a will and how to go about drafting one?
Research tells us that fewer than 15% of South Africans have a will when they pass away. It is, however, a crucial part of financial planning. A valid will is needed to make sure that your assets are distributed in accordance with your wishes. Welcome to Everything Counts. In this bi-weekly podcast series, we're frank about money and the particular discussions we should all be having. How to save it, how to spend it, how to grow it, its pitfalls, and how to make it work for us. On Everything Counts, we'll share the information you need to get your financial ducks in a row. Hello, my name is Moteo Khwaripe, host of Everything Counts. Joining us to answer this very important question are Lieze-Marie Brink and Jacques van Niekerk, both members of the Investec Tax and Fiduciary team who have extensive experience in advising clients on personal estate planning. Welcome to you both.
Thank you for the introduction, Mateo.
Thank you, Mateo. It's nice to be here.
Let's start with a stat I read recently, which said that 70% of South African adults don't have a will. Now, why is this? Thabo says he's unsure he needs one. Is part of the reason not knowing when it is necessary to have a will? Now, some of us will think we need to get assets, a property, a few cars, some shares as well. When does one get a will?
Thanks, Mateo. I mean, if we break down the research, it shows that the biggest reasons for not having a will is that you simply just don't have time, too busy to draft one, it's too expensive to prepare a will, or I don't really need one because of my asset base, the point that you just alluded to now. Yet in South Africa, we have 8.7 million homeowners, we've just over 5 million car owners, and 5 million single moms that have no wills. This is alarming. Common misconception is that you need wealth for it to be relevant to have a will. And this couldn't be further away from the truth. The only document that you effectively have where you have the freedom to dispose of your assets when you one day pass away is your last will and testament. We always get asked the question, when is the best time to start with estate planning? And the right answer to that is yesterday. The next best day to start with your estate planning is today. So the will is always the first step in doing so.
And people often ask, how much is this going to cost me? Because once you get someone that's a professional that's putting and organizing your life together, you need to pay them a little bit. Is it a fortune that I need to let go of, or they're reasonable rates?
Very reasonable rates. Over and above the online wills templates that are available, out there by various financial institutions and banks, it really should not cost an arm and a leg for a wills consultation to sit down to have properly drafted will prepared. We do have to caution, though, against the free wills, that is being advertised, everywhere in the industry, because there's no such thing as free advice. We've often seen that free wills consultations and free wills drafting services are being advertised, but with the little asterisk behind it in the fine print that says that if we draft your will, we'll be appointed as the executors of your estate.
And terms and conditions always apply.
Absolutely, yeah.
So what does life look like when you don't have a will?
That's a very important question, and something, unfortunately, if we look at the stats in South Africa, happens far too often. I think it's important to kick off here to bust two very common myths that exist. The one being that if I do not have a will, my assets go to the state. This is not true. And if I pass away, my assets will automatically devolve on my partner, my life partner, or my spouse, which isn't necessarily true. When I pass away without a will or without a validly executed will, the laws of interstate succession, it's legislation that will effectively dictate what happens to my estate when I pass away. And I'm going to highlight here an unintended consequence for Thabo, who's not married, he has no children. He might have a very good relationship with his cousins. He might have a very close affiliation with some charitable organizations. Thabo passes away without a valid will in place. So the laws of interstate succession will always draft I would say almost like a family tree to find the closest blood relative to Thabo. So in the absence of a spouse and children, they will go to the parents. In the absence of parents, they will go to his siblings. And the courts will effectively draw that family tree as wide as they possibly can until they find the closest blood relative to Thabo.
And what are the essential elements to include in a will to ensure that it is legal in South Africa?
So firstly, a person must be over the age of 16 before they can draft and prepare a will. When preparing the will, I think it goes without saying, they should be of sound mind, not be under any influence or coerced into preparing the will. Secondly, the will must be in writing. And this means that the will can be either typed or handwritten. The will needs to be signed by the person whose will it is on each page in the presence of two competent witnesses. And these two competent witnesses needs to sign and attest to the will in the presence of the individual preparing the will. This is something we far too often come across in the industry where wills are dropped off and it was signed by the testator or the testatrix at home and with a little sticky note, on the front page saying, will you please witness the will that I've dropped off? And that could invalidate the will because the witnesses now are neither in a position, if they were ever to be called into a court of law, they can't attest that the testator or the testatrix at the time of signing the will understood what he was preparing, understood the legal consequences of the will. He was under no influence or coerced into doing so because they weren't there when the will was signed.
So who do you need then as those witnesses? Because it's quite important. Are you picking family members at this point or people that you can easily call or the executor can call?
That's a very good question. The witnesses that witness and attest you signing your last will and testament should not be anybody mentioned in the will and should not be a person that either directly or indirectly stands to benefit from the will. Because that could always open up the grounds for external parties looking in, saying that these individuals coerced you into making these wishes during the time of drafting your last will and testament. And then I think very importantly, the original will is the most important document. So often we find that clients have signed a will a couple of years back. They don't know where the original is, but they've got a scanned copy on their desktop and on their laptop somewhere. We can't use that copy. An original will on your passing needs to be filed with the Master of the High Court before your deceased estate process can start. And I think it's very important to just highlight here that in a case where the original will is either lost or destroyed and there's only a copy of the original will available, such a copy can be accepted by the master, but this is a very lengthy and potentially costly process where an application will have to be made to court for an order declaring the copy of the original will valid.
So essentially you have to prove that that scanned copy was the original copy. Then.
Exactly.
So you're creating more admin for yourself.
Yes.
So for many young people like Thabo, the starting point may be to use will templates, for instance. Are these good enough in terms of making the documents legal?
For Thabo, with a very simple balance sheet, Thabo might have just acquired his first home. He's got a car in the driveway. He has no kids that he knows of, no spouse, no life partner. An online template should be more than sufficient to deal with these matters on his passing. But should there be any complexity to Thabo's family dynamics or a change in life events, it is advisable to seek professional help. If you have only a will that you've prepared, through an online wills template, it's better to have a will in place than have no will at all.
Now, Lieze-Marie, the misconception I had before I drafted a will was that you do it once and you do it right and you put it away forever, but you have to constantly look at your will as the years go by.
Yeah, very, very important. We normally say to clients, you need to actually read your will through once a year. So you need to review it. And I also want to say not just your will. Think about your beneficiary nominations on your retirement funds, as well as the beneficiary nominations on your life insurance policies, because you really want to look holistically and make sure that all of those nominations and your will is still very much fit for purpose. What we always say to clients is when big life events happen, there should be a little light bulb going off in your mind that says, my will, I need to go and relook my will. So maybe let me list a few of these light bulb moments when you really need to be mindful of changing your will. The first one would be death. Right. So if anybody that was in your will going to inherit from you pass away, you need to look at for your heirs in terms of your will. Secondly, if you get married or if you enter into a life partnership, you need to go consider, do you want your new spouse or life partner to benefit? And if so, add them to your will. Divorce is the interesting one, right? So in terms of legislation, from the date that you get divorced, it's as if they give you a 3-month window period, right? In which if you were to pass away in those 3 months, your ex-spouse would be seen in the eyes of the laws as if they have died before you and therefore not inherit, right? After 3 months, it's back to normal, what's standing in your will. Your ex-spouse can then benefit again. So the idea behind it is that if you don't change your will within 3 months, it was your intention to let your ex-spouse benefit.
I see.
And that's why it's very important. If you get divorced, think about your will. Obviously, children, if you get children, very, very important that you do planning specifically for minor children. And then also when you receive a large sum of money, suddenly you have more assets and you need to think about who's going to get those assets should something happen to you. Last point, and this is not just specific to your heirs. It could be very specific to who you nominate as an executor, who you nominate as a guardian in terms of your will. If in terms of your will you set up a testamentary trust, those trustees, as people are immigrating and moving abroad, it's very, very important that you go consider what is the role that they need to perform. Can they do it from offshore?
Yeah.
And could there be any tax implications? So, for example, if an executor moves to Australia, for example, it's a country that could possibly have tax implications. And by virtue of the fact that the executor is now sitting administering the estate from Australia, it could drag that whole South African estate into the Australian tax net. So very important when people immigrate, relook whether it's still fit for purpose.
Fascinating conversation. We're going to take a short break, and when we come back, we'll address one of the most important considerations when drafting a will, your marital regime, and making provision for your children.
Do you ever feel overwhelmed by all the admin you need for your home, estate, and family? Between marriage certificates, passport copies, and trying to keep track of your latest will, it's a lot. Yes, it's important to have the hard copies somewhere safe, but you also need digital copies. So, protect and secure your most important documents with Investec Private Vault. As a leading private bank, we give you unlimited complimentary storage for all your digital documents. Simply log into Investec Online or the app to get started with Investec Private Vault.
And we're back here on Everything Counts. An important consideration when drafting your will is, of course, your marriage regime. What should we consider when it comes to drafting a will and your marriage?
Now, there are various types of marriages/relationships that are governed and acknowledged in South Africa in various ways. You have your civil marriages governed by the Marital Property Act. You can have a marriage in terms of the Civil Union Act, which caters for same-sex and opposite-sex marriages. Customary marriages, religious marriages in terms of Hindu or Muslim rights, to name but two. And don't forget about life partnerships. A very important recent constitutional court case has now afforded life partners the same rights in various parts of our legislation as a spouse in terms of a marital regime. When we look at life partnerships in South Africa, as has become the custom with younger generations that decide that a traditional marriage might not be what they wish to enter into, but they wish to live together as life partners. What's very difficult about this is the one life partner passes away and the other life partner wants to rely on various pieces of legislation to be afforded the rights of a spouse. The difficulty here is proving it. You've got on the one side two friends living together. They've lived together for 15 years. And on the other end, you have two individuals that live together as life partners with the intention that there's permanency in the relationship and there's reciprocity. Whenever life partnerships are involved, it's important to get the necessary advice and potentially document the relationship in the form of a life partnership agreement or even a cohabitation agreement.
Yeah, so in South Africa, I think it's very important to know that we have freedom of testation. And what that means is we can decide, what do I want to give to who? There's nobody that is enforcing you to give a specific asset to a specific person. But before a person can actually start inheriting from the deceased estate, we first need to determine what is the assets that is in your estate. And this is where marriage regime comes into play. Even before any inheritance are distributed, there would need to be a look at what is the marriage regime of the two spouses. Marriage comes to an end by death or divorce, right? So that triggers this question about your marriage regime. Now let's make it practical. If you're married in community of property, remember this is the regime where what's mine is yours and yours is mine, and we share 50-50 in the communal estate. So firstly, the communal estate would need to be divided, and on your 50% of the assets, that can then devolve in terms of your will. If we think about being married out of community of property with the accrual system, right? Now remember, this is the regime that works basically what's mine is mine and what's yours is yours. But when our marriage comes to an end by death or divorce, we split 50% in the growth of all the assets during our marriage. So can you see the impact here? One spouse may have an accrual claim against the estate of another spouse. So effect would need to be given to that accrual claim first. And then once you know what's left over, then we know what is the assets that need to be dealt with. And then it can devolve in terms of your will. So life partnerships are normally backed by a life partnership agreement. So if that relationship comes to an end, either by death or divorce, then effects to that agreement would need to be given.
And I think in addition to the marital regime considerations, consideration should also be given to the religion of the spouses or the life partners, as the estate in certain circumstances could devolve in accordance with prescribed religious tenets. So even this is something to consider when drafting a will. If this is something that you wish to give effect to because you do have freedom of testation, but on the other end, if there are religious tenets that prescribes how your estate should devolve on your passing, this is something that has to be taken into consideration when your will is prepared. For Muslims in South Africa, Sharia law could be applicable to their estate. And in terms of Sharia law, there are certain tenets that have to be adhered to in terms of how your estate would devolve on your passing.
And how does one then meander through a joint will? Because marriage also comes with making decisions like that.
Yeah, that's a very good one. And actually, that's something that happened in our family. My mom and dad had a joint will, right? And probably 2 years before their passing, we said to them, no, you each should have your own will. It could be mirror wills of each other, which means as they kind of bequeath their assets very similarly, but have your own will. Thank goodness they actually amended their wills because my dad passed away within 12 months from the death of my mom. And if you had a joint will, what would have happened is that will on the passing of my mom, who was the first one, would have gone to the master's office, the original will. And I'm not sure if we would have been able to get it back out of the master's office. Because it does take some time, yeah. Exactly. What worked out well was my dad had his own will. So when he passed away, we could start the process of the administration of his estate because we could take his original will and hand it into the master's office. When it comes to joint wills, it's really recommendable that you actually, each person has their own will. And as we said, they can be mirror wills of one another, but it's just from an administration perspective, because once you lose the original will, it becomes very problematic.
Now, turning back to the will contents themselves, there are various assets that one might need to address in their wills. What should be listed, what shouldn't be listed, and how can you handle bequests of valuables that aren't specified in that particular will?
Yeah, I think to answer this, I can refer back to one of our previous podcasts where we were saying, what is a will and what is this thing called a letter of wishes, right? So I think the biggest thing to know is the will is the most important document, and it's in that document that you need to assign all the assets that you want to get to your heirs. Any wishes concerning the distribution of your estate should ultimately be included in your will. Where a letter of wishes comes into play is that it's a separate document that can just provide helpful guidance for the distribution of your personal items and minor assets that maybe you didn't specifically detail in your will. Here's a good example. In my mom's will, she said, my jewelry, I would like to go to my 2 daughters, right? So in terms of the will, both of us were entitled to share half fees in her jewelry. Right? But what she did is in a letter of wishes, she actually kind of specified it a bit bit better. She said, because I'm the eldest, I can get her wedding ring and my sister can get my grandma's wedding ring. So that's something that you could consider doing. Be very, very mindful of the fact that a letter of wishes, even though it is taken seriously by an executor, it is not legally binding. So if you want to make sure that that diamond ring gets to a specific person, you must make sure that you list it in the will for it to be binding.
Jacques pointed this out earlier on in the conversation, how important it is to keep the documents safe. Do you get a safety deposit box? Is it under your mattress? How do you make sure that your loved ones also find it when they need it?
Yeah. So I know normally if you go draft a will, for example, with an attorney, they sometimes have fire safes that you could keep an original copy in. Normally when we advise clients, we say to them, sign 2 copies as original, just so that if the one gets lost in the process, there is at least a backup document. And then it is very important that you speak to your family about where you keep your will. That's also not something that when you're not there anymore, they need to go look for and they can't find it. That will put undue stress on them. So talk to your family about your will, the content of your will, and where you store it. And I even want to go one step further and say your life file. If you've got a life file, tell your family about it. Tell them that you've taken the necessary steps to get that in order and where it is. I think it's very hard for us to speak about death. It's such a taboo topic almost. It's like, I don't really want to think about that. But I promise you, it gives you so much peace of mind when you actually broach the subject with your loved ones. It makes everybody sleep better at night.
I suspect what makes it hard then is people finding out before you die what they're going to get and whether they'll be happy with that. And you'll have to ask and answer a few questions as well. Jacques, that conversation, sitting your family down, I mean, you can talk about somebody getting a Ferrari. It's a great conversation, but if they're not getting anything from you at all, that's a tough conversation to have.
It's a very tough conversation to have. But ultimately, your wishes would have been conveyed upon your heirs and upon individuals who stand to inherit nothing from your estate. But what this does remove out of the equation is future disputes in terms of the validity of your will and whether you were of sound mind when you prepared your will and whether the wishes that you've captured on the last will and testament actually gave effect to your wishes. Benjamin Franklin once said, in this world, nothing can be said to be certain except death and taxes.
Yeah.
We're always talking about taxes. This could be around the campfire or the dinner table, but death is rarely discussed or planned for in the same way. We should really get rid of the stigma attached to discussing death. We should have open and frank discussions with our loved ones in terms of our wishes and ultimately make sure this is recorded in a valid will and testament.
Well, I think that's a great place to end. Lieze-Marie and Jacques, thank you very much for joining us for this episode of Everything Counts. Next time on Everything Counts, we're discussing some of today's points in more detail. Earlier, we had mentioned the life events that can trigger the updating of your will. For instance, when Thabo gets married or he decides to start a family, there are new aspects of estate planning he needs to consider. Here we'll discuss deeper implications of trust, guardianship, and special needs. You won't want to miss this critical discussion. Don't forget, you can also send your questions using the hashtag Investec Everything Counts.
The views expressed are those of the contributors at the time of publication and do not necessarily represent the views of the firm and should not be taken as advice or recommendations. Investec Private Banking, a division of Investec Bank Limited, a registered credit provider committed to the Code of Banking Practices as regulated by the National Financial Ombudsman.